Welcome to Epstein Becker Green's Employment Law This Week podcast. I'm George Whipple. Today marks the 100th day of the new administration. When President Trump took office on January 20th of this year, he promised to transform the government, and the speed and scope of change in the first 100 days has exceeded those expectations. Here's Paul DeCamp.
There's been an enormous amount of activity across a broad range of programs throughout the administration. It's been very intense.
Here's Aaron Schaefer.
The administration immediately rescinded many policy memos that the prior administration had in place.
Here's Jim Petrie.
The number and breadth of the executive orders is unprecedented. The president has issued 130 executive orders in just 4 months.
But just how all that activity will translate into lasting change remains an open question. Here's Aaron Schaefer.
Major changes have come in the form of removing executives, which has really slowed down the agency's ability to act. But from a policymaking perspective, there haven't really been that many changes yet.
Here's Jim Petrie.
President Trump has not sought to pass legislation to make the changes that he seeks more permanent.
As we look back on this historic first 100 days, we asked my Epstein Becker Green colleagues what changes they think clients should be focused on. Here's Paul DeCamp.
A big issue for our clients is the current administration's focus on DEI initiatives. The change in position, the change in view, and the current hostility toward DEI programs has caused a lot of concern for many of our clients, and they're watching that issue closely.
Here's Susan Gross-Shalinsky.
The administration is essentially promoting the dismantling of DEI programming in favor of what it refers to as merit-based practices. Guidance from the EEOC and the DOJ takes the position that DEI training can actually constitute discrimination or harassment in the form of creating a hostile work environment, and that potentially segregating employees when they receive such training or when they receive other privileges of employment could be unlawful as well.
Here's Aaron Schaefer.
Clients should be aware that the administration has rescinded many of the policy memos that the prior administration had in place. That means that where the prior administration was trying to change the law, those efforts have stopped, and that will increase latitude for clients in terms of how they operate their businesses.
Here's Paul DeCamp.
The change that will have the most long-lasting impact that we're seeing in the current administration is the willingness to push the envelope regarding the independence of agencies that traditionally have resided somewhat outside of Article 2 of the Constitution.
That's something that's currently being litigated at the Supreme Court. But if this issue continues to play out, it will make the National Labor Relations Board and other similar agencies much more responsive to changes in the White House.
While transformation has been the focus in the first 100 days, we've also seen an administration willing to take on new frontiers like cryptocurrency and AI. Here's Adam Foreman.
We're seeing quick and rapid changes in lots of areas that don't directly touch on workplace AI, but tangentially do. And I think employers need to be nimble, and they need to be practical, and they need to be looking from many different lenses to protect themselves, their workers, and to be compliant. The change in the Trump administration's first 100 days regarding workplace AI tools that employers should really be most focused on is to not be lulled into a false sense of security or belief that the use of executive orders somehow alleviates or somehow takes away their obligations or exposures under existing law, whether that's federal, state, or local.
Thanks to my partners for their insight, and thank you for listening. We'll be here with all the latest in employment law for the next 100 days and beyond. We'll see you next time.
This podcast is presented by Epstein Becker Green, PC. All rights are reserved. This audio recording includes information about legal issues and legal developments. Such materials are for informational purposes only and may not reflect the most current legal developments. These informational materials are not intended and should not be taken as legal advice on any particular set of facts or circumstances, and these materials are not a substitute for the advice of competent counsel. The content reflects the personal views and opinions of the participants. No attorney-client relationship has been created by this audio recording. This audio recording may be considered attorney advertising in some jurisdictions under the applicable law and ethical rules. The determination of the need for legal services and the choice of a lawyer are extremely important decisions and should not be based solely upon advertisements or self-proclaimed expertise. No representation is made that the quality of legal services to be performed is greater than the quality of legal services performed by other lawyers.